Texas has one of the most landlord-friendly tenant screening environments in the country, with minimal state-level regulation and a strong property rights orientation. If you're screening tenants in Texas, the federal FCRA and Fair Housing Act are your primary compliance frameworks. The state has not enacted the screening restrictions found in more regulated states. Texas's regulatory philosophy is simple: the market governs, and landlords have broad discretion in selecting tenants. Let's start with application fees. Texas does not cap application fees. There is no state statute limiting what a landlord can charge for tenant screening. Landlords can charge whatever amount they consider reasonable. The Texas Property Code, found in Title 8, addresses various aspects of the landlord-tenant relationship, but does not restrict screening fee amounts. However, Texas does have a specific provision regarding application deposits, which are distinct from application fees. Under Section 92.351 of the Texas Property Code, if a landlord collects an application deposit, money intended to hold a unit while the application is processed, the landlord must refund the deposit if the applicant is rejected, unless the parties agree in writing that the deposit is non-refundable. This distinction between application fees paid for the cost of screening and application deposits paid to hold a unit matters in Texas. The screening fee itself is generally non-refundable, but a deposit to hold the unit may need to be returned depending on the written agreement. Best practice is to clearly label your charges, specify what is a non-refundable screening fee and what, if anything, is a refundable application deposit, and get the applicant's written acknowledgement before collecting any money. Criminal history screening in Texas is unrestricted at the state level. Texas does not have a ban-the-box or fair chance housing law. There are no state-level restrictions on when or how landlords can inquire about criminal history. Landlords can ask about arrests and convictions on the initial application, can use criminal history as part of their screening criteria without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. No Texas municipality has enacted a local ban-the-box housing ordinance. Austin, the most politically progressive major city in Texas, has enacted a fair chance hiring ordinance that restricts criminal history inquiries in employment, but this does not extend to housing. Houston, Dallas, San Antonio, Fort Worth, and every other Texas city operate under the same unrestricted framework for housing screening. Texas's preemption laws also play a role here. Texas has enacted broad preemption statutes in various areas of landlord-tenant law, and the state's political environment makes it unlikely that individual cities will enact local screening restrictions that conflict with the state's market-based approach. However, landlords should still monitor local developments. Austin in particular has an active tenant advocacy community. HUD's 2016 guidance on criminal history and disparate impact applies in Texas. While Texas courts have generally been less receptive to expansive fair housing theories than courts in more progressive states, the federal risk still exists. Blanket policies that reject all applicants with any criminal record can violate the Fair Housing Act if they disproportionately impact protected classes without legitimate business justification. Texas landlords who apply proportionate, documented criminal history criteria, considering the nature and severity of the offense, how long ago it occurred, and its relevance to the tenancy, are in a stronger position than those who apply automatic rejection policies. Source of income protection does not exist at the state level in Texas. Landlords are not prohibited from considering the source of an applicant's income. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. No Texas municipality has enacted a local source of income protection ordinance. This gives Texas landlords complete discretion over whether to participate in voucher programs and whether to accept applicants whose income comes from government sources. For credit reports, Texas follows standard FCRA requirements: permissible purpose, written consent, and adverse action notice procedures. Texas does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond what FCRA mandates. Texas does have some unique provisions in its property code that affect the screening context. Under Section 92.3515, a landlord who requires an applicant to provide a consumer report or criminal background check as a condition of the application must accept a report provided by the applicant if the report was prepared within a certain time frame. Though the practical application of this provision depends on the specific report type and the landlord's verification needs. Some Texas landlords accept portable tenant screening reports to speed up the process, while others prefer to pull their own reports through their screening provider for consistency and verification. Texas's fair housing protections are found in the Texas Fair Housing Act, Texas Property Code Chapter 301. The Act prohibits discrimination based on race, color, religion, national origin, sex, disability, and familial status. Mirroring the Federal Fair Housing Act, Texas has not added additional protected categories such as sexual orientation, gender identity, marital status, age, or source of income beyond the federal baseline. The Texas Workforce Commission's Civil Rights Division investigates fair housing complaints. While the state fair housing law mirrors federal protections, some Texas cities have enacted local non-discrimination ordinances with broader protections. Austin, Dallas, San Antonio, Fort Worth, and El Paso have local ordinances that include protections based on sexual orientation and gender identity. Landlords in these cities should be aware that their local ordinance may provide broader protections than state law, and screening decisions that appear to target applicants based on these locally protected characteristics can result in local enforcement actions. From a practical standpoint, Texas has one of the largest and most diverse rental markets in the country, with several major metros that rank among the most active in the nation. Houston, the state's largest city and the fourth largest in the country, has an enormous rental market driven by energy, healthcare, including the Texas Medical Center, the largest medical complex in the world, NASA's Johnson Space Center, the Port of Houston, manufacturing, and a massively diverse economy. Houston's rental market ranges from luxury high-rises in the Galleria and River Oaks areas to workforce housing across the sprawling metro. Houston has no zoning laws, which creates a uniquely diverse development pattern. The applicant pool is extremely diverse, and landlords screen tenants from virtually every background and income level. Dallas-Fort Worth, one of the fastest-growing metros in the country, has a rental market driven by technology, financial services, telecommunications, defense, including Lockheed Martin and multiple military installations, healthcare, and corporate headquarters relocations. The DFW metro has attracted enormous population growth, and rents have increased substantially. Landlords in DFW generally have strong pricing power and a deep applicant pool. San Antonio has a rental market heavily influenced by the military. Joint Base San Antonio encompasses Fort Sam Houston, Lackland Air Force Base, and Randolph Air Force Base, making it one of the largest military complexes in the country. Military tenants represent a huge portion of San Antonio's rental market. Landlords near military installations should understand military income documentation, leave and earnings statements, BAH rates, and the Service Members Civil Relief Act. San Antonio's BAH rates are moderate relative to other Texas metros. Austin has the tightest and most expensive major rental market in Texas, driven by technology, including Tesla, Apple, Google, Meta, Oracle, Samsung, and hundreds of startups, the University of Texas, state government, and an influx of remote workers and corporate relocations. Austin's rents increased dramatically in recent years before moderating somewhat as new construction has added supply. The applicant pool in Austin skews younger and more tech-oriented, and competition for quality units is intense. El Paso has a more affordable market influenced by Fort Bliss, one of the largest Army installations in the country, the University of Texas at El Paso, and cross-border commerce. Military tenants are a major factor in El Paso's rental market. College Station, Lubbock, Waco, Denton, and other Texas college towns have student-influenced markets where screening applicants with limited credit and rental history is a regular challenge. Having a consistent cosigner or guarantor policy is essential for landlords in these markets. The Rio Grande Valley, including McAllen, Brownsville, Harlingen, and Edinburgh, has affordable markets with unique demographics and screening considerations. Landlords in the valley serve a diverse tenant population and should apply screening criteria consistently across all applicants. One best practice for Texas landlords, even though the state imposes virtually no screening restrictions, develop and document your screening criteria in writing. Having a clear policy that specifies your credit score threshold, income-to-rent ratio, criminal history evaluation standards, rental history requirements, and any other factors creates consistency and protects you if a denial is challenged. Apply those criteria uniformly to every applicant. The absence of state regulation doesn't eliminate the need for a defensible screening process. Federal fair housing law still applies. Another best practice: clearly separate your screening fee from any application deposit in your written materials. Texas law treats these differently, and conflating them creates confusion and potential refund disputes. Label each charge clearly, explain what each covers, and get the applicant's written acknowledgement before collecting any money. Texas has no statutory limit on security deposits. The deposit amount is governed by the lease terms. Landlords must return the deposit within 30 days of the tenant vacating. The flexibility on deposit amounts provides financial protection, but thorough screening remains the most cost-effective way to avoid problem tenants. Even an unlimited deposit doesn't compensate for the cost and disruption of evicting a bad tenant. For the complete guide to Texas tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.